Nevada is often talked about as being the best trust jurisdiction in the United States, and that just isn't true. So today we're going to talk about the top 3 myths related to Nevada trust laws. So let's get into it. All right, spoiler alert, Nevada is not the best trust jurisdiction in the United States. And today we're going to talk about 3 myths related to asset protection, privacy, and dynasty trust in no particular order. But we're going to debunk some myths related to Nevada trust laws. Nevada's done an amazing job of marketing itself as the top trust jurisdiction in the United States. And that isn't to say that it's not a really solid option. But if you are going to the trouble as someone who doesn't live in Nevada, looking for the best trust jurisdiction, then you don't want to settle for Nevada. You want to go to South Dakota. So top 3 myths. So the first one is related to privacy. So there isn't great privacy, or I shouldn't say there isn't any guaranteed privacy when it comes to trust laws in Nevada. So what do I mean when I say that? So if there is any type of court hearing, any type of court proceeding related to a trust in Nevada, the details of that trust can become part of the public domain. A great example of this is recently with Rupert Murdoch, who very, very wealthy billionaire from, I believe, England, who has many business interests, including Fox News, among other news outlets. But he had a Nevada trust. There was a bunch of issues related to his family dynamic, and a lot of the details related to the trust became part of the public domain. So the judge in Nevada has the discretion when to decide to seal any of the details related to the trust that come out in the court hearing. And then the seal is only guaranteed up to 3 years, as opposed to South Dakota, who has a automatic perpetual seal forever related to any trust details that come out during a court proceeding. So again, Nevada touts itself as having these great privacy laws, and that just isn't true. It's not that they have bad privacy laws, it's just that they aren't the best. So South Dakota has an automatic seal that lasts indefinitely, whereas in Nevada, it is up to the judge's discretion, with some limitations on what they can actually do. All right, so that's privacy. Number 2, let's talk about asset protection. Nevada always touts itself as being the best trust jurisdiction in the United States because of its asset protection trust laws. All things considered, Nevada and South Dakota are nearly identical, except in one regard. So Nevada will say that it has no exception creditors when it comes to asset protection trust. And that is true. And that means that so the idea behind an asset protection trust, I should say this first, is that personal creditors aren't able to pierce the trust if there is a personal creditor claim against, say, a beneficiary, or maybe the person who set up the trust. So personal creditors can't get to that. There are no exceptions to those creditors. Some states have exception creditors. There's some creditors that they say are the exception to that rule and will allow a personal creditor claim to be able to be enforced against that trust. South Dakota does have exception creditors. However, that needs to be discussed with a small nuance that's really important. The only time that South Dakota allows it is when the person has an already outstanding alimony obligation or a child support obligation. Those are the only exception creditors in South Dakota. So if you don't have those issues before you set up your South Dakota trust, then you're fine. I personally have never had anyone come to me who has outstanding alimony or child support obligations and ask for a South Dakota domestic asset protection trust. In fact, I would never help them with that because I think that is absolutely ludicrous that Nevada allows that. I think it's a horrible public policy consideration, and I think it speaks to the fact that it's Las Vegas's Sin City reputation. So if you want to support that, then I guess that's fine. Or if you want to go there because you do have those types of creditors, child support, alimony, then Nevada is your option. But if you aren't up against that issue, then Nevada and South Dakota have exactly the same asset protection trust laws. There is no difference. Its statute of limitations is exactly the same. But again, the privacy, as I said in the first bullet point, is much better in South Dakota. So let's talk about the third thing, and that's dynasty trust planning. So historically, trusts are only allowed to exist for a certain amount of years. So there was this rule, it's called the rule against perpetuities. I won't go into great detail about that, but basically a trust has a shelf life. And once the trust hits that shelf life, then the assets have to be distributed from the trust, and therefore making them susceptible to exposure related to creditor claims, as well as wealth transfer taxes, estate tax, inheritance tax, generation skipping tax, etc. So states started doing away with that. Back in the 1980s, South Dakota was the first state to completely do away with this rule against perpetuities, meaning they were the first state to create a true dynasty trust, dynastic trust planning. That means that the trust, the family wealth inside that trust, can live inside the trust forever. The trust doesn't have any shelf life. So you're going to continue to protect those assets over many generations, as opposed to Nevada. Nevada talks about dynasty trust planning, but it doesn't even have the best, it's done away with the traditional rule against perpetuities, but it hasn't done the best compared to other states when it comes to that. There is still a shelf life of trust in Nevada. It's 365 years, which is a long time. Like, it's nothing to complain about. It's better than a life in being plus 21 years, which is what the rule against perpetuity said. Some states still have that rule against perpetuities. Some states say it can last 100 years, 365 years, 90 years. South Dakota says it can last indefinitely. Nevada says 365 years. So the point is, if you're going to the trouble to look for the best trust jurisdiction, why would you settle for 365 years when you don't have to? You can have indefinite trust planning. Those assets are protected from personal creditor claims, and you have indefinite privacy related to any details related to the trust. And one other thing that I should probably add that I didn't mention related to the privacy is that South Dakota has what's called quiet trust laws, meaning that the settlor, the person setting up the trust, can dictate how much information the beneficiaries of the trust are allowed to have related to the trust. Most states, when a client or when a beneficiary hits 18, then they have the ability to know about the trust and the trust details, what their benefit is, as opposed to South Dakota, which goes a step much further and says, no, the settlor wants to completely eliminate the ability of the beneficiaries to know about the trust or know details, then the settlor can do that. So that adds to that privacy issue even more. So asset protection, privacy, dynastic planning, they are not the best when it comes to Nevada trust laws. South Dakota is much better.